rise. Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. Good morning. This is the time set for oral argument in Dipasquale versus Dipasquale, our case number CACV 160356FC. Each side is allocated 20 minutes for oral argument. Appellant may reserve a portion of that time. If you wish to do so, you need to keep track of your own time using the clock at the podium. Out of respect for counsel, I would ask those in attendance to make sure your cell phones are off so our conversation today is not interrupted. We have read the briefs. We've conferenced the case. We're familiar with the record. We'd encourage you to keep that in mind during oral argument today. Our proceedings are being recorded, will be posted to the court's website and then in due course to YouTube. So please, as you begin your presentation, tell us your name and the party that you represent. With that, Ms. Davis, you may proceed.
Good morning. May it please the court. I'm Helen Davis, and I'm appearing with my partner, Philip Gerard. We represent the appellant, Helen Virginia Dipasquale. I'd like to reserve 5 minutes for a rebuttal argument. This case is before you today because the trial court refused to join Joseph's current wife, Susan, as a party to a post-petition enforcement action for spousal maintenance arrears, such that Joseph's contribution to his new community could be litigated and established for purposes of collection. In doing so, Judge Cooper found that her refusal to join was based on the fact that this was not an issue for the family court. In 1995, the Arizona Supreme Court, in the seminal case of Marvin Johnson, held that there is but one superior court. And neither of the parties technically disagree that Judge Cooper had the authority to grant the motion to join. Where the disagreement lies is that the appellee, Joseph, argues that Helen was required to sue Susan back in 2006 after she filed the first petition to enforce the spousal maintenance orders. And he claims that that is required by 25215B. We disagree. His argument is based on a number of cases, fairly old cases, in fact, Eng versus Stein, C&J, Visky, Spudnuts, those types of cases, none of which are factually consistent with this family law case. They're all contractual obligations, not support obligations. None of them were dealing with the enforcement of a support or arrearage judgment. In fact, technically, the only Arizona case that we have found that is factually on point with this case is a very old case, and that's the Gardner case, forgive me. That case was decided, though, by the Arizona Supreme Court in 1964, and that was before the legislature amended Title 25 to add 25215. The next closest case that we've found that deals with a similar support issue is Hines. And that case was decided post-amendment of Title 25. But at Hines, while it addressed support, it addressed child support, and it did not address the core issue in this case, which is technically when do you have to sue the new spouse to get at the community. Recently, this court, very recently, decided another case, Jensen versus Byrne. And that case, while not factually similar, conceptually, from a policy perspective, indicated that the Superior Court retains jurisdiction to do justice in family law cases. As you've certainly read, both counsel, on behalf of their clients, rely on the Flexmaster decision, but for different reasons. You'll see that Joseph relies on that case to argue hey, you had to sue Susan back in 2006. We rely on that case to say we have to add Susan now. We have to bring her in to allow her, to afford her her due process rights to litigate the issue regarding Joseph's contribution to the community.
Counsel, let me ask you.
Yes, Your Honor.
With respect to whether suit or process needed to be initiated in 2006, is that an issue we need to wrestle with?
Well, I suppose, Your Honor, you could decide that Judge Cooper was incorrect in finding that she didn't have the authority in the family court to decide this issue, and you could reverse on that basis alone.
Well, but let me ask you, because to use the far more comfortable for me civil analog,
Sure.
where there's a motion, as an example, for leave to amend a pleading. An objection to that may be that it's futile. And if well-suited, that may be a reason to deny the motion to amend. But I don't get the flavor from my understanding of this record that futility is the path that Judge Cooper walked. And help me better understand that, either correct or confirm that understanding of the record.
Well, I wasn't the lawyer down below at the trial court, but from the record and my understanding, you're absolutely right. Futility wasn't the path that Judge Cooper walked, Your Honor. She said that this was premature and that it wasn't an issue for the family court. And frankly, I've been a family law practitioner for 20-some years now, and so pretty familiar with the process down there. And I do know that from an approach perspective, the family court judges don't believe that they should be dealing with enforcement actions. They do, at least many of them, have a perspective that that is a separate civil action, where I tend to disagree, and I think this case brings it into broad focus, that the family court is the civil court, just as the probate court was the civil court in Marvin Johnson.
If you take that argument to its logical extreme, however, that would mean that the court had to grant the request to join. And I don't take that from my reading of Rule 33.
I don't take that from my reading of Rule 33 either, Your Honor, but under 25215B, in order for Helen Dipasquale to collect against Joseph's community with Susan, she had to be joined to the suit at the time that we want to pursue collection.
But that, under Flexmaster, means she had to be joined to a suit, right?
A suit, yes.
Because Flexmaster was not a family court matter. It was
That's right.
civil sort of division, not garden variety, because it came here and had a published opinion. But so Flexmaster really talks about the substantive requirement. Wouldn't you agree?
I would agree.
And Rule 33 and the family court rules talks about the procedural avenue that could, one way, where that could happen.
Exactly. And you can see in the various support cases, support enforcement cases, like Jarvis and Sanchez, for example, those cases, and even Hines, even though Hines didn't get to the issue of when or whether you had to sue the new spouse, because as Flexmaster pointed out, Hines didn't, they didn't object to the garnishment as to the, I believe it's the husband's wages, so they never got to the issue. Sanchez and Jarvis say, listen, you don't even have to file a petition for a judgment when you're pursuing support. Once that original decree is entered, that original decree establishes the support obligation, and every payment that's unpaid is a judgment by operation of law. And so that's where support diverts from a regular civil judgment. Like you see these cases, Eng, Visky, these cases are dealing with fraud, torts, contractual obligations. Support is a completely different animal. Susan never would have been a party to the consent decree that established the support obligation in the first place.
And to that point, Ms. Davis, wasn't the property settlement incorporated into the party's consent decree and adopted by the Superior Court shortly after the consent decree was entered?
It was incorporated into the consent decree at the time the decree was entered, Your Honor. Yes.
So that would be Joseph's obligation to pay was basically established at the time that the consent decree was entered.
Absolutely, in 2001. Well before 2005. And if you look, at the payments, back when the original enforcement action was filed a few months after Joseph married Susan, and Helen wasn't pursuing community property at the time. I mean, what community property could have existed? I mean, they were married for seven months when that action was filed. So you take a look at that already. I sort of like calculated out there were 47 months out of 61 of unpaid spousal maintenance. It's not like it was all post new marriage spousal support. That was just not an issue at the time. And I think it's important to think about this issue from a practical perspective as well, because what would be the impact of a decision that the new spouse had to be sued in the first enforcement action when, I mean, if you think about that, nobody does that. No family law practitioners are routinely suing new spouses. In 20 years, this is the first time that I've had this issue arise. And on top of that, where a former spouse, isn't even required to file a suit to pursue or get a judgment, they can just garnish. Under Sanchez, you can just go out, and Hines, you can just go out and garnish. You do not have to have the arrearage basically calculated and reduced to a single number, such that, really that's for ease of understanding what is exactly, what amount are you pursuing, and usually to get some sort of an arrears and purge payment put into place so that you might have some, the benefit of contempt is really the benefit of filing a contempt action, and to enforce is, jail often makes people pay. And so
So let me ask you, what specific relief are you seeking?
We're asking that you remand, that you decide that, yes, the family court had the authority to join and address the issue under 215B of the new spouses and Joseph's relative contributions to the community, so the enforcement could occur against that community property, and that she should have, Judge Cooper that is, should have granted the motion to join, so that it's remanded with instructions that we can proceed to establish Joseph's contribution and then move to collection.
Well, that's where I think, I'm sorry.
No, go ahead.
That's where I think you may be a bridge too far for me, Ms. Davis, because as Judge Thumma pointed out, Rule 33 is permissive, and Judge Cooper may join additional parties necessary for the exercise of her authority. So where you might have had me in the remanding back and possibly remanding back for her to reconsider this, with us maybe fleshing out that she does have the authority, you think we should instruct her to join Susan under 215B. Is that correct?
That is what I said. Yes, Your Honor, I did say that. I mean, I would be happy if you remanded back and told Judge Cooper that she had the authority in her court to address this issue, and then she could decide. But I do think that we need to know as a bar how you deal with 215B, because if Mr. Brown is right, it changes everything.
How?
Because the impact on support arrears is massive. Because you have all manner of persons like Helen Dipasquale who have judgments outstanding where they may not necessarily have needed to pursue the new community property. There was income maybe of the obligor spouse, but the time comes when they need to do that. And if Mr. Brown is right, those support orders will be unenforceable. You will reinstitute the $2 bankruptcy. You will reinstitute it because somebody can get married and that new community wasn't sued because nobody does that. Nobody has to do it for the collection of support. The only time it arises is when you express it like this case where this gentleman has avoided his support obligations for what, 16 years? And, Helen, first they settled. He was supposed to make some payments. There was an agreement not to execute if he did so. He didn't do that. Then you're back, a number of years later. So I think that it's important to decide what is required by 215B when you're dealing with a support award and to guide the superior courts and the bar so that everybody understands what we're supposed to be doing. Because at this point, the only case out there is Gardner. And Gardner said, pre-215B, right? But Gardner said, hey, support's not a contractual obligation. Support is a duty. Support is something you owe the spouse. You can't throw the spouse away like an old shoe. You can't do that. And so we ask that you remand both to notify the superior court, the family court in particular, that it has the authority to decide this issue and to give instructions about how to decide it in light of 215B. I'll reserve the rest of my time.
Thank you. Mr. Brown.
Good morning. I'm Harvey Brown. I'm here with Joshua Conway, and we're from the law firm of Ayers & Brown. We represent Joseph Dipasquale. In hearing Ms. Davis's argument, I am a little confused as to the fact that nowhere was mentioned sole and separate versus community, because that's what we really have in front of us. Judge Cooper was correct when she said you need to do some sort of collection process so that we can look at 25-15 and we can determine whether when you attempt to collect a sole and separate debt that you collect it out of the debtor's community property, because that's really what 215 says. This became a debt and a sole and separate debt from the entry of the decree in 2001. It was bundled together in 2006, and it was bundled together about 10 months after Mr. Dipasquale married Susan, his present wife. If it was necessary at that time to go after the community and to name, as Flexmaster tends to say, to name both husband and wife, then Ms. Davis should have named the husband and wife at that time. And then we could have litigated a very clean type of a matter. At this juncture, it isn't clean. What we have,
Let me ask, is.
Sure.
So your position is Rule 33 would have been an appropriate mechanism to join her in the second wife, if you will, in this same family court matter to duke that out in 2006. It was just that appellant waited too long.
partly.
I wondered if there might be more, but.
Yeah, partly. I don't think that based upon, the community property laws, that in 2006, appellant could have named the new wife. My belief is it was a judgment. We don't tinker with judgments very often. And this was a judgment, and this was a judgment that was entered in 2001. It continued on a monthly basis. There were lots of reasons why Mr. Dipasquale wasn't in contempt. There was illness issues, there was other issues, but as a judgment, we have Mr. Dipasquale still liable to Helen for the full amount of the aggregated spousal maintenance plus the 10% interest that attaches to it. That doesn't go away. We're not asking that it go away. What the issue really is whether or not Judge Cooper could have joined Susan, the new wife, in the action to enforce the judgment. It was an enforcement action. If it had been a different type of action, a collection action, as Judge Cooper indicated, then we would be able to determine if Helen wished to enforce the judgment, what assets she wished to enforce it out of, and therefore to determine whether or not the community property of the new marriage was subject to, and if so, how much.
But Mr. Brown, isn't that was exactly what the appellants were trying to do in joining Susan? They were asking for her to be joined and then have the evidentiary hearing that you had on other issues that were decided by Judge Cooper also decide this other issue about what part of the community is sole and separate that Helen may make a claim to, but that was thwarted by Judge Cooper ruling that this wasn't an issue for family court.
We have a judgment, Your Honor. I disagree. I think that appellant was trying to make Susan as a judgment debtor rather than just bring Susan in as a party. That could have happened in all sorts of different ways. It should not have happened in an enforcement action. If appellant wished to determine what property existed, or if appellant wished to determine whether or not Susan had any community property that would be subject to the collection of a sole and separate judgment, there were many, many, many ways of doing that, and there still are. It just can't be done in an enforcement action. That's the first thing. Secondly, you can't amend the judgment. So the judgment has to stay with Mr. Dipasquale. It can't be attached to Susan. By bringing her into an enforcement action, you confuse the sole and separate aspect of the judgment with how you collect the judgment, which is clearly 25-15. It says how you can collect the judgment when there's a new community. You have a sole and separate judgment, you collect it out of the judgment debtor's portion of the community. You don't need a new spouse. The better question is, what happens if the judgment debtor dies, and now we're stuck with having attached to that judgment a new spouse that is not obligated in any fashion? And the difficulty with spousal maintenance is that it is a sole and separate judgment, and it never, ever, ever becomes a community judgment with a new community. Because of that, Judge Cooper may have been inarticulate in determining her reasons for doing that, and saying, take it to the civil court. I think that was an inarticulate statement. The reality is, she went on to say, there's been no collection efforts taken against any property, so because there's been no collection efforts taken, we don't know what property is community and what Joseph's share of the community can be utilized to satisfy this judgment.
Isn't that the process that you just described, the collection process, that's an adjudicative process, right? I mean, that there likely would be competing claims as to what was and what was not
Correct.
Sort of attachable. So, and you'd mentioned probate, which could, at least in a theoretical different case, become in play as well. And so doesn't the effect of Judge Cooper's ruling here say, well, you need to go across the hall to a civil division and initiate a case there for a collection? And if something horrible happens to one of the parties, you may also need to go down another hall to a probate division to initiate a proceeding there. And then something will happen, and one of those three courts, or maybe two or all three, will decide who ought to get what if it's something other than what we know we have in hand right now. Isn't that kind of the one way to look at a picture you're painting?
It is.
Okay.
It is. I'm not going to tell you it isn't. I will tell you, however, that Ms. Davis has been 25 years. I've been 46 years, or almost 46 years, doing family law, and I have pursued claims in other courts for different than this reasons. We have pursued probate courts. We have pursued collection efforts using a commissioner in the Superior Court to collect. Well, that's what would happen. If there was a garnishment, it wouldn't necessarily go to a judge. It probably would go to a commissioner. So that occurs on a routine basis.
And I think both parties are in agreement that there, at least in theory, are other ways, depending on how deeply you get into the facts, there are other ways that this could have been done outside of family court division. But the question is, to the extent the record shows that the Superior Court found this couldn't be done in family court, was that right?
Probably not. And I say probably because I don't know the specifics of what the judges in family court do. I have had judges transfer the case because of other expertise to other divisions. Mm-hmm. And that could have easily been done. I think the problem here is that it was an enforcement of an existing judgment in order to, in theory, collect that judgment, and that's why the appellant wished to join Susan to this case. if Ms. Davis filed a petition for contempt, which she could have filed, although the problem is it was reduced to a judgment, so petition for contempt may or may not have lied in this particular instance, but that was a remedy. There are other remedies, and any of them could have been utilized. The problem with filing a request to join a third party when you already have a judgment, the only basis for that is to join that third party to the judgment. The appellant got what they could get. They got a judgment. That is in fact what all of the civil cases, all of the litigated cases, the case that was here before, that all they want is a judgment, and that's what appellant has.
That's
Now,
not what I read in appellant's brief. I don't think they stated anywhere in their brief, and correct me if I'm wrong, Mr. Brown, if you could cite me to it, where the appellants are making the argument that they're seeking to join Susan to the judgment. And I'll ask that same question of Ms. Davis when she comes back, but I don't think that they're seeking to join Susan to the judgment. Am I wrong?
Well, they didn't say that. You're right. What the effect is since the only thing out there was the judgment, that was the only thing that.
Well, what else is out there is their community property that they can bring in. They can have a hearing to determine what is Joseph's contribution to that community, therefore can be attached, and Helen can get at, so to speak.
I'm sorry.
Correct? They can. That's an avenue that they're seeking to pursue, and that's something that they could do in family court. Would you agree with that?
I would agree with that. I would also agree that they could bring Joseph in the stand. They could subpoena Susan for the normal processes of asking questions. They can do a judgment debtor exam with Joseph, asking him about his property. They can do all those things. The problem is the only thing existing in family court in 2016 was the amount that was owed and the judgment that they had obtained. That was the only thing existing. The marriage was dissolved in 2001. Joseph and Susan didn't get married until 2006. After they got married, the judgment the judgments were all compiled, and what we have is all the property is done, all the issues are resolved except for one, and that is they have a judgment, they want to enforce it. And by bringing Susan in, the only remedy that a court could have is to attach her to that judgment. That's the only remedy. I mean, they could bring her in, but there would be no reason to bring her in except for the judgment attachment. Now, if the cases that Ms. Davis discussed say you have to join a spouse if you want a community judgment. Well, they'll never get a community judgment. It will never be a community judgment. By its terms, spousal maintenance is sole and separate property. The judgment that they got was sole and separate property. The combined judgment that they asked for in 2006 was a judgment only against Joseph even after he married, so it was a sole and separate judgment. Bringing Susan in 10 years after she and Joseph were married doesn't do anything. Community property stays community property. It never changes. Sole and separate property can be changed to community property, and that was the only, or maybe the only, issue that existed. So bringing Susan in doesn't do anything for the appellant. She can collect the judgment the same way she could collect it 10 years ago. And I think Judge Cooper was inarticulate. I think that she should have not made reference to a civil court. She probably overspoke because she had already ruled on it before, and then came back when we were litigating other aspects. But she was correct. I mean, while her statements may have been wrong, she was correct. You can't add a new spouse to an old judgment. I don't think you can add there's some litigation out there in some of the cases that you have a judgment, and if you want to file a separate action on a new spouse to bring them into the judgment, you might be able to do it if the debt that you're seeking to enforce incurred after the marriage, but you have a sole and separate judgment. In this case, it could never happen. And by adding her to the judgment, you only, the only issue before the court was the judgment. Her bringing into the litigation would do nothing except attach her to the judgment, which would amend the judgment, which would wreak havoc with the judicial system, which would ignore community and sole and separate property rules. Yes, this is the only case I found in Arizona, and quite frankly, I think that unfortunately it falls upon you to deny appellant the right to join this third party. Thank you.
Thank you, counsel. Ms. Davis, you have the last word.
Thank you, Your Honor. A couple of points. We were never, Your Honor, seeking to convert the judgment basically into a judgment against the community. That is never what was asked. That relief was not requested. What was requested is that Susan be joined to, I just hope you're okay, Susan be joined to the enforcement action so that we could litigate the issue of Joseph's contribution to the community, because there is no separate property. The only separate property there is Joseph's share of the community property. And under 215B, you have to, it is required to name that new spouse who has a share of that community. That's what due process requires. That's what we've been arguing the whole time. And that's what Flexmaster says. That's why we're both relying on Flexmaster, but Flexmaster says that the new wife's interest in community property is a due process right, and to litigate both the premarital debt and husband's contribution, and you don't have to file a new lawsuit. The second point I'd like to make is that you're also correct, Judge Bean, that we were there in a collection action. It's called a petition for order to appear to enforce, but that was a collection action. We were there saying to the family court, he hasn't paid his support, make him pay. And what Judge Cooper decided was that she couldn't do that. That wasn't for the family court. We needed to go off across the hall, as I think Judge Thumma, you said. We needed to go across the hall, and if we were going to institute a garnishment or some kind of attachment, some sort of execution process, we couldn't do it before the family court. And what was argued down below to Judge Cooper is that if that's what was required, then that required Helen to litigate potentially over and over and over again what Joseph's share of the community was. And in some situations, I can foresee different types of enforcement actions at different points in the parties' lives, but these folks are pretty advanced in age. So there aren't a lot of assets out there to pursue. Finding out in one forum what Joseph's contribution to the community is so that that could be collected against is what we were trying to do. Mr. Brown said that there are many other ways to proceed. I don't know of any other ways to proceed. I don't know what else we could have done but ask the court to allow us to join Susan under 215B so that we could figure out what assets, what portion of those assets were collectible.
Ms. Davis, there may be other ways. I don't know off the top of my head, but this would certainly be one of the most, if not the most convenient form in which to do that. Is that correct?
Absolutely, Your Honor. It is the most convenient forum because you're talking about support obligations. The family court is familiar with support obligations, and the family court has the unique ability to determine what is community and what isn't. I mean, who better? They decide, those judges decide that every day. In fact, federal courts, bankruptcy courts defer to the state courts as a matter of routine when it comes to character issues. And so that is the best place to decide. Your Honors, Judge Cooper didn't decide that we couldn't bring Susan in to create a community judgment. What she decided is that this issue was premature and it wasn't an issue for the family court. But it is an issue for the family court. There is but one superior court. And Gardner, I know I hearken back to Gardner, but Gardner says that you can continue to collect that support against the community. And so we would like you to remand with instructions that Judge Cooper has the authority to join, and that here is what happens under 215B when you're dealing with a support judgment. Thank you.
Thank you, counsel. We appreciate your presentation today and our discussion today. We appreciate your written briefs. We will take the matter under advisement. We'll issue a ruling in due course. We stand adjourned.